Good afternoon, good morning, good evening, wherever you are. My name is Nguyễn Dzung, Director of ADI Vietnam Chamber. Welcome all of you to the first webinar of the ADI Vietnam Chamber. The topic of the webinar today is ad hoc arbitration in maritime and insurance sector. I would like to introduce to you Mr. David Steward. Mr. David Steward is an arbitrator and mediator. He is the president of the London Maritime Arbitrator Association, the NMAA. NMAA is recognized as a center of excellence in maritime dispute resolution. For over 30 years, he practiced as solicitor with a national law firm in the city of London. David is practicing as a solicitor in April 2011. And since then, he has been wholly independent. He now sits as a sole arbitrator of the Arbitrator at 10 Fleet Street Chamber, or as a member of the Chamber on a range of the commercial dispute with particular focus on maritime cases, including shipbuilding and offshore energy contracts. He also has experience of arbitration under the term of, among others, ICC, NCIA, and the NMAA. Mr. David Stewart practice has a particular focus on the Europe, US scope, and the Asia Pacific region, including Singapore, Malaysia, South Korea, Vietnam, Brunei, Indonesia, and Japan, and the Middle East. So we would like to introduce Mr. David to present his presentation. David, the floor is yours.
Thank you very much, Dzung, for that kind introduction. And thank you to everybody for inviting me to speak today. It's a great pleasure to be taking part in this webinar. I'm only sorry that I can't be there in Vietnam with you in person. It has been far too long since I visited Vietnam, particularly because of the COVID pandemic, and I hope that I will be able to visit again next year. So let me share my screen with you so you can see my slides. So I'm going to be talking today about ad hoc arbitration, and I will refer to maritime and insurance arbitration in London. I hope this will give you some useful guidance for your arbitration in Vietnam. So first of all, what is ad hoc arbitration? Well, in London, we use the term ad hoc in two different ways. It can mean an arbitration which is not subject to any agreed rules or procedures. And in that case, it's governed only by the Arbitration Act 1996. It can also mean an arbitration which is not administered by an institution such as the ICC or the LCIA. So in that sense, ad hoc means non-institutional arbitration. And that is the subject of my talk today. And LMA arbitration is a very good example of that kind of ad hoc arbitration. Now, first, I would like to tell you a story. This is the story of my first experience of maritime arbitration. And it shows, I believe, how ad hoc arbitration can work at its best. This was in 1980. I was very junior. I had just begun my training contract with a law firm in the City of London. And there was a dispute under a charter party in relation to a safe port warranty. The ship was sitting off a port in Africa, and the master was waiting for instructions from the ship owners as to whether he could go into the port or not. As soon as the two law firms were instructed, a sole arbitrator was appointed. He was a former chartering broker, and he had many years of experience of these clauses. There were no formal pleadings, no disclosure of documents, no witness statements or experts' reports. I went down to the arbitrator's office with the two lawyers, and over tea and biscuits, they made their submissions. The arbitrator gave his decision verbally the same day, and he issued his formal award a day or two later. Of course, one party was unhappy because they had lost the argument, but this was a good result for both parties because the dispute was resolved very quickly and it enabled them to go back to work. Now, that was a very quick example, and there's no reason in principle why an ad hoc arbitration cannot take a similar form nowadays. particularly where the dispute is over the interpretation of a contract term, but nowadays it tends to be more formal. Usually lawyers are always involved on both sides, not always, but mostly. Submissions are far more complex and legalistic than before, as are procedures, and those procedures can sometimes resemble court proceedings in bigger cases. As a result, a lot of arbitrators in London now have some legal background or alternatively qualifications from the Chartered Institute of Arbitrators. So here's a brief history of London maritime arbitration. There is a long-standing tradition of maritime disputes being resolved by commercial people in London. And the roots of this go back over the history of the Baltic Exchange. Prior to 1744, the Virginia Coffee House in the City of London was a place where merchants traded goods from America. Then the Virginia and Baltic Coffee House was established. The addition of the word Baltic reflected the growing importance of the Baltic Sea market in commodities. Over time, trade in the city expanded and it became too big for a coffee house. Also, there was concern among traders that the market was unregulated with speculation and unacceptable practices. To provide high standards of trust, the new Baltic Mercantile and Shipping Exchange opened in the early 20th century. Over time, the practice grew of arbitrations being conducted, often informally, by members of the shipbroking business. The LMAA was founded in 1960 at a meeting of the Baltic Exchange Arbitrators. And since then, the membership of the association has been expanded. The list of our practicing arbitrators now includes people from a variety of backgrounds with a wide range of experience and expertise. Maritime arbitrators may be solicitors or barristers. Some of those lawyers have worked in private practice, or they may have been claims handlers in P&I clubs or FD&D clubs, freight demurrage and defense clubs, which provide insurance for legal expenses in shipping matters. But arbitration is not limited to lawyers. We also have former mariners, marine engineers, naval architects, brokers, and commercial people who have worked for ship owners or charterers. For insurance arbitration, there is a similar organization. ARIAS, A-R-I-A-S in the UK, is a not-for-profit society founded in 1991 by members of the legal profession dealing with insurance and reinsurance disputes. It is part of AIDA, the Association Internationale de Droit des Assurances, and ARIAS have members who work in the insurance and reinsurance markets or who are retired and who act as arbitrators. They publish their own arbitration rules, including fast track rules. Now, like the LMAA, ARIAS is not an institution. Arbitration under their rules is ad hoc. It's necessary for us to look briefly at the Arbitration Act 1996. And the reason is that both the LMAA terms and the ARIAS rules work together with the Act. The Act creates a framework for arbitration. It sets out the purpose of arbitration and the duties of the parties and the arbitrators. It makes provision for matters such as the appointment of arbitrators and the powers of the court to assist arbitration. It also contains a limited right of appeal on issues of law subject to the permission of the court. But it does not contain detailed procedures. For example, there is no timetable for submissions in the Act or any deadline for the issue of awards. Under the Act, the arbitration tribunal in each case has the power to decide all procedural and evidential matters. So terms such as the LMAA terms and the ARIAS rules build a structure onto this framework. They set out detailed procedures, and in some cases, they simplify the provisions of the Act. The Act contains some very important general principles for ad hoc arbitration. In particular, by section 1, the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Under section 33, the arbitrators must act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent. The arbitrators must also adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, so as to provide a fair means for the resolution of the matters falling to be determined. So you'll see that the general principles under the Act emphasize two things. One is fairness, and the other is efficiency, cost efficiency and time efficiency. Now, some people say that they prefer institutional arbitration because they think the institution will supervise the arbitrators and keep control of the proceedings. However, the duties under the Act apply to all arbitration, including ad hoc arbitration. So tribunals must always comply with them. I believe that experienced arbitrators in the maritime and insurance sectors are perfectly capable of maintaining standards of conduct and ensuring fairness in arbitrations. And in any case, they are subject to the supervision of the English court at all times. Now, under the Act, there are duties on the parties too. Under section 40, they must do all things necessary for the proper and expeditious conduct of the arbitral proceedings. The Act also reflects the importance of party autonomy, the power of the parties to make decisions as to how the arbitration will be conducted. The parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Party autonomy is at the heart of the LMAA terms. In practice, arbitrators encourage the parties to try to agree on procedural matters, though the arbitrators will make orders on strict terms if this is necessary in order to keep the arbitration moving. What about appeal? Well, the rules of some institutions, such as the ICC and the LCIA, exclude any right of appeal against arbitrators' awards. There is no such exclusion in the LMAA terms, although the small claims procedure, which I'll talk about later, does exclude appeals. There are two views in England on appeals against arbitration awards. On one hand, parties want to know that they will have some remedy if a tribunal gets the law badly wrong. On the other hand, parties want finality. When they start an arbitration, they do not want to be looking at the prospect of a long series of appeals to the Supreme Court. They want to get a decision, put the dispute behind them, and get on with their business. So it is necessary to strike a balance between those two views. My personal opinion is that the 1996 Act strikes a very good balance. A party can appeal only on questions of law. They have to apply to the English court for permission to appeal, and the court will give that permission only if the tribunal's decision is obviously wrong, or the question is one of general public importance and the tribunal's decision is at least open to serious doubt. That is a very high threshold. In London arbitration, very few appeals get to court, and even fewer are successful. In my experience, the English court is keen to support arbitration. The LMAA reviews its terms and procedures frequently, with a view to keeping up with developments in the arbitration sector and reflecting the views of our users. The latest revision was issued on the 1st of May 2021. And in addition to the main terms, we publish a small claims procedure, which we call the SCP, and an intermediate claims procedure, the ICP. The parties can choose to agree to apply these procedures either in their arbitration clause or even after the dispute has arisen. Nowadays, the SCP, the small claims procedure, is often used for disputes below $100,000. The president of the LMAA can appoint a sole arbitrator if the parties don't agree on one. And in that case, a small administration fee of £350 is payable. Otherwise, there is no fee chargeable by the LMAA. The claimant under the small claims procedure pays a single fixed fee of £4,000 to the arbitrator in advance to cover all his or her work up to and including the award. No part of that fee goes to the LMAA, it all goes to the arbitrator. So it is not an administration charge. If the case settles before the award is issued, the arbitrator can retain part of the fee and must repay the balance to the claimant. There is a tight timetable for submissions and for the award, and there are also word limits for submissions. There are no witness statements, and there can be experts' reports only if these are permitted by the arbitrator. There is no formal disclosure of documents. The parties just produce with their submissions the documents on which they rely. And there's no hearing unless the arbitrator requires this. And the arbitrator will do so only in very exceptional circumstances. Almost always, under the small claims procedure, the arbitrator makes a decision based on the written submissions and documents. The ICP, the intermediate claims procedure, is designed for disputes which are not small enough for the SCP, but not big enough to justify the use of the full LMAA terms. It may be used, for example, for disputes between $100,000 and $400,000. But the parties can agree on the limit in their arbitration clause. So the ICP is a streamlined procedure with a very strict timetable. And if a party wants to apply for an extension of time, it has to apply before the deadline expires. There are also caps, limits on the costs of the parties and the tribunal. When hearings take place now in London, they are held mostly at the International Dispute Resolution Centre in Paternoster Lane near St Paul's Cathedral. The IDRC has large, well-equipped rooms and technology for virtual and hybrid hearings. In the old days of Baltic Exchange arbitration, lunches were communal. The arbitrators sat with the lawyers and the parties all together and usually had a very good hot lunch with a bottle of wine. But now lunch is taken separately. The arbitrators have their own room and there is no alcohol. What is a maritime dispute? What kinds of disputes are resolved in ad hoc maritime arbitration in London? Well, maritime arbitrators deal with more than just disputes over carriage of goods by sea under charter parties and bills of lading, although those are still central to our work. Maritime arbitration can include almost anything which floats or is fixed to the seabed. We hear disputes under contracts for the building of ships, drilling rigs, and specialized vessels for the energy industry. Our offshore energy work extends to both oil and gas and renewable energy, particularly nowadays wind farms. There are many wind farms being developed off the coast of the UK. BIMCO, the Baltic International Maritime Organization, publishes a number of standard form contracts which contain a dispute resolution clause. This provides often for London arbitration on LMAA terms as the default. These contracts include the hire of boats in the energy sector, heavy lifts, and the decommissioning of offshore installations. In the field of shipping, maritime arbitrators deal not only with conventional cargo vessels, but we frequently see disputes involving the building, sale, or chartering of yachts and super yachts. Maritime arbitrators also handle disputes in international trade, the sale, purchase, financing, and carriage of commodities. So let's look at some key features of ad hoc arbitration. One, there is ease of access to arbitrators. The arbitration can be started quickly in an ad hoc arbitration. So, for example, for LMAA arbitration, you start simply with appointment of the arbitrator. The party or their lawyer can make this appointment by direct contact with the arbitrator, usually either by phone or email. You do not need to make a formal request for arbitration to any institution or secretariat. The arbitrator will check for conflict of interest, but they then usually accept the appointment very promptly, often within minutes. There is no bureaucracy. This helps the parties to get their arbitration started quickly, and that's particularly useful when there is some urgency. For example, I had a case recently in which the parties to a shipbuilding contract wanted a quick decision of the tribunal because the delivery date was approaching and there was a dispute about the amount payable on delivery. 2, the parties have free choice of arbitrators, any nationality, qualifications, or profession, subject to the usual considerations of independence and conflict of interest. Parties in ad hoc arbitration are free to choose their arbitrators. The choice does not require the approval of the LMAA. Sometimes an arbitration clause will specify qualifications. For example, in charter parties, we see clauses requiring that the arbitrators will be commercial people or members of the LMAA or members of the Baltic Exchange, but that is a decision for the parties. 3, cost effectiveness. Because there is no institution, there are no administrative charges in ad hoc arbitration. A small fee is charged by the LMAA if the president is asked to appoint an arbitrator, but this happens only in a very small number of circumstances. For example, in default of agreement between the parties on the choice of a sole arbitrator. 4, the parties can choose terms and procedures which are appropriate to their dispute. Depending on the amount in the dispute, they might use the main LMAA terms, or the intermediate claims procedure, or the small claims procedure. 5, no time is taken in drafting and agreeing terms of reference. This can be very slow in international, institutional arbitration. I had a case where I was appointed in an institutional arbitration a few years ago, where it took something like 3 months to get the terms of reference agreed and signed by the parties before any progress could be made in the arbitration. This is not necessary in ad hoc proceedings. Instead, in LMAA cases, the parties exchange questionnaires after completion of written submissions. The 3rd schedule to the LMAA terms sets out the form of the questionnaire, and by reference to these questionnaires, the parties and the tribunal consider directions for the future conduct of the reference. The tribunal usually allows the parties 21 days to agree. So again, there's party autonomy at work. We try to encourage the parties to come to agreement. But to the extent that they do not agree, the tribunal then makes directions itself. 6, there is structure to ad hoc arbitration where there are terms that apply. So although, for example, the LMAA does not administer the arbitration, nevertheless, there is a clear structure under the terms and procedures, including timetables and powers for the arbitrators. The parties do not have to rely solely on the provisions of the Arbitration Act 1996. 7, some institutions review and approve the arbitrator's award, and that takes time. This does not happen in ad hoc arbitration. For example, the LMAA leaves the award to the discretion of the arbitrators. So when the arbitrators reach their decision, they can publish their award promptly, and there is no delay while the award is reviewed. The LMAA terms say that the award should normally be available within 6 weeks from the close of proceedings. And in many cases, and in particular where there is some urgency, the time taken should be substantially shorter. So you can see our aim is to publish awards in ad hoc arbitrations very quickly after completion of the proceedings. One difference between institutional arbitration and ad hoc arbitration is that institutions collect the arbitrator's fees. Usually they require deposits in advance for those fees. This does not happen in ad hoc arbitration. So how do the arbitrators protect themselves? How do they secure themselves for their fees? Well, the arbitrators can always exercise a lien on the award and refuse to issue it to the parties until they have been paid. But this does not in itself give them enough protection. For example, the parties might agree to a negotiated settlement of the case before an award at a stage when the arbitrators have incurred significant fees. The LMAA terms contain a first schedule which deals with the arbitrator's fees. The arbitrators can charge interim fees at intervals of not less than 3 months. If those fees are not paid on time, an arbitrator can, in his discretion, resign. The arbitrators can also charge non-refundable booking fees in return for fixing a hearing date. And they can also require reasonable security, which is often given in the form of an undertaking by lawyers or by an FD&D club. All of these terms are designed to ensure that in ad hoc arbitration, the arbitrators are protected for their fees. Let's look at some key features of maritime and insurance arbitration. Arbitrators decide disputes in accordance with the law. Because we have a common law system and not a civil code in England, we are bound by the precedent of judgments of the English court, but we are not bound by decisions of other arbitrators. However, many arbitrations are reported in an anonymized form in the London Maritime Law newsletter, which is published by a company called Informer. The awards have to be anonymized because of confidentiality, but there is enough of a summary to provide the reader with information of how the arbitrators have decided the case. Parties will sometimes refer arbitrators to those reports in the hope that they will be persuasive and that the arbitrators will consider making their decisions consistently. There is an advantage in having arbitrators who are experienced in the maritime and insurance sectors. If they have worked in those sectors themselves, they will understand the commercial background to disputes, and in particular, the business considerations of the parties. So in maritime cases, they may also have served on ships or as technical consultants, which will help them to understand issues as to navigation, engineering, or operational matters. Similar considerations apply in insurance arbitration. The arbitrators may have been underwriters, brokers, loss adjusters, or lawyers who specialize in insurance or reinsurance cases. This is very important because if you have a lawyer or a former judge who has general experience but not specialized experience, there can be a learning curve. It can take time to explain the technicalities, and the arbitrator may not be aware of the commercial background. What happens if you have two maritime arbitration references which are connected in some way? Often, for example, there is a chain of charter parties. If so, it is common to have back-to-back arbitrations with the same tribunal. In that situation, where the parties appoint the arbitrators, it is very important for the parties to discuss this in advance to try to ensure that the same arbitrators are appointed in each reference. Sometimes the president of the LMAA makes appointments, for example, the appointment of a sole arbitrator under the small claims procedure. In that situation, the parties can ask the president to appoint the same arbitrator in all the references, and the president will always try to do so. This avoids duplication of cost, and it avoids the risk of inconsistent decisions. Now, also, there may be cases which arise out of the same set of circumstances. Ad hoc arbitrators in the UK do not have power to consolidate arbitrations under either the Arbitration Act 1996 or the LMAA terms. In order to consolidate arbitrations, it is necessary to have the consent of all the parties. It has to be done by agreement. But we do have power under the LMAA terms to run arbitrations concurrently. Paragraph 17b of the terms reads as follows. Where two or more arbitrations appear to raise common issues of fact or law, the tribunals may direct that they shall be conducted and, where an oral hearing is directed, heard concurrently. Where such an order is made, the tribunals may give such directions as the interests of fairness, economy, and expedition require, including that time limits for service of submissions may be abbreviated or modified in the interest of saving costs or minimizing delay or otherwise enhancing efficiency, that the documents disclosed by the parties in one arbitration shall be made available to the parties in the other arbitration upon such conditions as the tribunals determine, and that the evidence given in one arbitration shall be received and admitted in the other arbitration, subject to all parties being given a reasonable opportunity to comment upon that evidence and subject to other conditions that the tribunal determines. Where there is a consolidation, it is not necessary to have the same tribunal in both cases, though it is more cost-effective if you do. The power to consolidate will usually be exercised only if there is at least one arbitrator who is common to both cases. And that power is available only where both the cases are governed by the LMAA terms or by other applicable terms which allow for consolidation. In maritime arbitrations, the majority of cases are settled commercially by agreement between the parties before the arbitrators make their award. Where there is no settlement, most cases are resolved by reference to written submissions and documents alone, without an oral hearing. However, if a hearing does take place, it may be in person with the parties, their lawyers, and the tribunal all present in the room. Alternatively, it may be virtual. In that case, everybody takes part online using Zoom or similar software. There is also a middle course. We call this a hybrid hearing, with some people present and some attending remotely. We try to avoid a situation where one party or its lawyers attend in person and the others attend remotely, because that can seem unfair. We say there has to be an equality of arms. But it is common for one or more witnesses to give evidence remotely. For virtual and hybrid hearings, we frequently use the assistance of the International Dispute Resolution Centre as moderators. This means that they control the use of the software and the access to the hearing. There are also companies in London, such as Opus 2, who manage the electronic bundles. They display the bundles on screens for the tribunal and the parties. In ad hoc arbitration, many arbitrators now use only electronic bundles. In practice, I never ask the parties for hard copy bundles unless there are very large documents such as drawings, which are difficult to view on a screen. The LMAA was one of the first organizations to publish detailed guidelines for the conduct of virtual and hybrid hearings. They are designed to be very practical. They cover the preparation for the hearing and also the etiquette at the hearing. For example, there is guidance on arrangements for a witness who is giving evidence remotely so that the parties can be sure that there is no one else present in the room with the witness. I usually ask the witness to move his camera around the room to show that he is on his own, and also to confirm that he has no mobile device with him when he's giving his evidence. Those guidelines are now in the 6th schedule to the LMAA terms 2021. It's also common in London to have a full transcript of the proceedings. This is created simultaneously as the hearing proceeds. It is then sent to the tribunal and to the parties at the end of each day. I find the transcript very useful when I'm writing an award, especially in a case with several factual witnesses and experts. Arbitrators have to be very careful about conflicts of interest. It is important that an arbitrator is always seen to be impartial. When an arbitrator is appointed, they should disclose anything which might cause a fair-minded and informed observer to think that there is a possibility of bias. And that duty continues throughout the arbitration. In ad hoc arbitration, because there is no institution to check on this, it is particularly important for each arbitrator to keep it in mind. There is a very important judgment of the Supreme Court in England in a case called Halliburton and Chubb. This related to claims arising out of the Deepwater Horizon blowout in the Gulf of Mexico. You remember the rig which suffered a blowout with catastrophic results a few years ago. The arbitrator accepted an appointment in an arbitration between Halliburton and Chubb, and he later accepted appointments in 2 other arbitrations which also related to the Deepwater Horizon incident. The English court held that in the arbitration between Halliburton and Chubb, the arbitrator was required to disclose those overlapping appointments. He had not done so, but the court concluded that a fair-minded and informed observer would not think that there was a real possibility of bias. The IBA guidelines on conflicts of interest in international arbitration do not apply compulsorily to ad hoc arbitrations such as LMAA proceedings. However, in practice, London ad hoc arbitrators often use them as guidance. The LMAA, for example, publishes advice on ethics on our website, which refers to the importance of independence and impartiality, among other things. Maritime arbitrators are often appointed on numerous occasions by the same party or by the same law firm or FD&D club. This is because they are chosen for their specialization and experience. It's very different from institutional arbitration, in which arbitrators may only have a small number of appointments each year. The IBA guidelines recognize this. In footnote 5 to paragraph 313, it is stated that no disclosure is required where all the parties in the arbitration should be familiar with the custom and practice. The Supreme Court took the same view in Halliburton and Chubb. However, we have to be particularly careful when there is a risk that parties may not be familiar with that custom and practice. For example, a company in the offshore energy sector might say that they do not recognize the custom and practice of the shipping industry. So often an arbitrator will make precautionary disclosure. They will say that they do not have a duty to make disclosure, but they do so in the interests of transparency. This helps to avoid the proceedings being disrupted if an argument is raised at a later stage. Different arbitrators have their own systems for recording their appointments. It depends on the individual. As an example, I practice through Arbitrators at 10 Fleet Street, and my clerk, Megan, has a record of all my appointments, including the names of the parties. I also keep a list of the law firms who have appointed me, which I update each time I receive an appointment, so that I can check the number of appointments which I have received from each firm. These records include inquiries which do not lead to an appointment, and also cases which have not progressed beyond an initial appointment. Now, we've been talking a lot about the arbitrator's conduct of ad hoc arbitration. Let's look now at the party's conduct. How do the parties handle the proceedings? First of all, it is very important that the parties review their arbitration clause before starting proceedings. This is particularly important in ad hoc arbitration because there is no institution to check on this. The parties must consider, for example, whether the dispute falls within the scope of their arbitration clause. They must consider also whether they and their opponent are parties to that arbitration agreement. They must ensure that they comply with the procedure for appointment of arbitrators and that they appoint arbitrators who comply with the requirements of the clause. If these checks are not carried out properly, there is a risk that the jurisdiction of the tribunal may be challenged, or even that any award may be unenforceable. The parties have a free choice of arbitrator in ad hoc arbitration, and for this reason, it's important for them to think about the kind of arbitrator that they want. For example, does the case involve difficult questions of law? Are there complicated technical issues for which it would be useful to have a member of the tribunal with an engineering background? And in the case of a tribunal of 2 or 3, it may be sensible for the parties to discuss in advance the makeup of the tribunal. For example, they might agree to have 2 lawyers and an engineer or a commercial person. I want to be sure that I leave time for some questions and answers, so I will keep myself to about another 3 or 4 minutes just to conclude some comments. In maritime and insurance arbitration, it's common for the parties to be represented by lawyers. We have a split profession in England, and often solicitors will prepare the case, organizing documents, taking witness statements, and engaging experts. Then at the hearing, they use a barrister for the advocacy. But ad hoc arbitration is often less formal than court proceedings, and it's not necessary to have a legal team. In smaller cases, particularly where there is no oral hearing, submissions may be written by claims handlers in FD&D clubs or by the party's own commercial people. And a solicitor may carry out advocacy on behalf of a party without using a barrister at the hearing. Now, finally, it may be helpful if I tell you a little about the way that arbitrators organize their practices in London. I practice through a group called Arbitrators at 10 Fleet Street. This is the arbitration wing of a barrister's chambers, quadrant chambers. However, I belong only to the arbitration group. I'm not a barrister, and I am not a tenant at quadrant chambers. I pay a fee to Arbitrators at 10 Fleet Street in return for services that they provide to me. That fee is a percentage of the income which I receive from my arbitration, so it's not a fixed standing charge, and I pay only according to what I earn. And the services which they give me are as follows. I have a clerk who arranges my billing. The clerk issues fee notes and sends them to the parties, containing a detailed breakdown of my time so that the parties can see how the fees have been calculated. The clerk also deals with inquiries from parties and law firms about potential appointments and keeps a record of my cases to check for any conflict of interest. But they don't market on my behalf. I have to promote my own practice. Now, not all London arbitrators belong to groups of this sort. Some full members of the LMAA are barristers by qualification, so they belong to chambers. Some arbitrators belong to groups called Arbitra and ArbDB, but not many members of the LMAA. Most LMAA members run their own practices, and they usually employ secretaries or personal assistants. So in summary, just to draw all this together, I believe that there are a number of advantages to ad hoc arbitration by comparison with institutional proceedings. In my experience, it is usually quicker and more cost-effective. Proceedings nowadays are quite formal, but ad hoc arbitration is very flexible. A good tribunal will keep a firm grip on the proceedings to ensure that they are fair and efficient. And the LMAA terms and the Arias rules are good examples of procedures which work together with the Arbitration Act to ensure that ad hoc arbitration is efficient. Well, thank you very much for listening, and I'm very happy to take some questions, and I will now hand back to Dzung.
Thank you, David, for your excellent presentation. Mr. David Steward will have to leave the webinar very shortly. So before listening to the other speaker, I would like to invite all the audience to put a question to him so he can answer your question directly. If you want to put a question, you just put the button of raise hand. So now I saw one hand raised, Mr. Nguyen. If you have a question, the host, can you open the mic for Nguyen, who may want to raise a question to David? Irina Klimova, the second one. Yeah, Nguyen, can you unmute yourself and put the camera on so you can make a question now? Hello, Nguyen, can you hear us? Host, can you open the mic for Nguyen, please? It's not workable, I think. I don't know why. Zhang, can you unmute Nguyen for his question? I cannot hear anything from Nguyen.
I already promote him to panelist, but I don't think it worked. Maybe he had to accept it.
Can you unmute? No?
Is Mr. Nguyen able to forward his question in the chat box?
Yeah. If you feel uncomfortable to appear directly, so you can put your question in the chat. What was the second? I think the second hand.
Yeah,
Irina
I already
Klimova.
allowed this.
Yeah, I can hear Irina Klimova.
Yes, hello, can you hear me?
Yeah, you can hear well. It's unmute now. Yeah.
Yes, hello, can you hear me?
Yes, hello.
Yes, good afternoon, Irina. We can see you
good
and hear
afternoon.
you.
Well, first of all, thank you so much for your extensive lecture. Really, really useful for us. And I just have a question which concerns whether the arbitration clause will be applicable to a certain type of claims. So right now we have a charter party where it is provided, and the arbitration clause provides that all the disputes should be referred to the LMAA arbitration when the amount of claim is below $50,000. So nothing more is provided in the arbitration clause. So there is a question. We have a claim which amounts to $250,000. Obviously, it doesn't fall under the provision. I mean, does it mean that a main procedure of the LMAA will be applicable or no?
That's a very interesting question, Irina. Thank you very much for that. You'll understand that I can't offer any legal advice on that, particularly because I've not seen the clause itself, but I understand the question. It's a very clear question, and thank you. If, as I understand it, the clause says that the LMAA terms will apply only below $50,000, then if you have a claim in excess of that, the LMAA terms will not apply under the arbitration agreement. So what I would think you would do in that situation is you would start an ad hoc arbitration under the Arbitration Act 1996. But it depends on what the clause says about arbitration and law generally. If you have, does the clause say that there will be arbitration in any event, or does it refer only to arbitration for claims below $50,000?
Well, as usual in charter parties, it just says that in capital letters that for disputes under $50,000, LMAA arbitration small claims procedure.
Okay.
So that's just the wording.
Okay. I see two types of clause sometimes. One is a clause that says that there shall be resolution of disputes in London arbitration. So that's a general statement. And then it says, for disputes under $50,000, LMAA small claims procedure will apply. Now, in that situation, if the claim is above 50,000, then you can still arbitrate because you have an arbitration agreement. If your clause does not have that general wording and says only, if it only refers to arbitration in connection with claims below $50,000, then my reaction is that you have no arbitration agreement in relation to claims in excess of that amount. So you can't start arbitration. You would have to consider whether you have grounds to start proceedings in the English court or whether you would have to commence proceedings somewhere else. But if there is a general wording that refers to arbitration, then even though the LMAA terms won't apply, you can still start arbitration. So let's take that as an example. Sometimes what happens is that the parties start an ad hoc arbitration and then they agree between themselves subsequently that the LMAA terms will apply. There's nothing to stop the parties from doing that. It's a very efficient way of proceeding. And even if they don't, the arbitrators will sometimes make directions in an ad hoc arbitration, which are very similar to the second schedule of the LMAA terms, because it's a very efficient and it's a good model for directions. So there is a possibility of agreeing these things, but I think the direct answer to your question depends on whether your clause has a general reference to arbitration or only arbitration for claims under 50,000. And if it's only claims under 50,000, then it seems to me you have no arbitration agreement for anything in excess of that amount.
Mm-hmm.
Is that helpful?
Thank you so much. Yeah, it is. It very much is. Thank you.
Thank you, thank you, David. The second question should came from Lilia Klochenko. So how can you please open the mic for Lilia Klochenko? And then the next one is Samatha. Yes.
Hello. Good
Lilia,
morning.
good afternoon.
I hope you can hear me. Yeah.
Yes.
We can hear you and see you. Thank you.
Thank you. Thank you very much. First of all, thank you very much for that great and very helpful presentation, David. It was
Pleasure.
really impressive. So I'm serving as an arbitrator and mediator in commercial maritime insurance reinsurance cases since 10 years or more. And I find your ideas very interesting and important, especially this balance between, for example, formality and bureaucracy, because yes, formality we need in our proceeding to tailor the proceeding in right and efficient way, but no bureaucracy in the pure ad hoc arbitrations or, so to say, institutionally administered ad hoc arbitration maritime cases. It is one of the pros. And I have one question that I'm coming back and back from time to time, and I'm discussing it also with myself and my colleagues. So you mentioned that it is, okay, common law system is based on the precedents, but yes, at the same time, the awards from the previous cases is not bound for the arbitrators, arbitration tribunals for the other cases. And yes, I see to some extent, sometimes the contradiction in this idea, because of course the awards of the arbitrators create some precedent. what do you think? Could we, in any case, or sometimes to some extent, take the awards from the previous cases as a precedent for the other cases?
It's a really important and interesting question, Lilia. Thank you for asking that. And like you, I have conversations about this with people a lot. It's very tricky. The strict position under English law is that the arbitrators' previous awards are not binding. You will be familiar with the fact that we have a hierarchy of precedent in England. So a Court of Appeal decision will be binding on a first instance judge and so on. And of course, all court decisions are binding on arbitrators. We have to apply the law as it's been established in the precedent. I think there are two observations I would make. One is that it is in the interests of the parties and the community generally that we try to achieve some degree of consistency in our awards. It would be, I often hear parties say, we've had two very different decisions from different arbitrators, and we find this very difficult because it means we aren't certain where we stand next time we have a dispute. So I think it is useful that we try to look for some consistency. But I think there are two practical difficulties. One is that we don't have full publication of arbitration awards. And there's been a lot of discussion about this recently. Should we do so? I personally am not in favor of full publication of all arbitration awards, partly because of confidentiality, which is central to arbitration, but also because so many awards are really quite routine. And it would be a huge administrative burden to produce lots of awards which are not very interesting and not very helpful. So one difficulty is that we don't have access to all the reasoning of the arbitrators. We have to rely on the anonymized versions which appear in the London Maritime Law newsletter. Now, those are very useful. They're very well prepared. They're prepared by expert lawyers who are very good at summarizing them. And I find in practice that quite often a party in an arbitration will refer me to reported arbitration awards. And yes, the answer to your question, I think, is that I will always give careful consideration as to whether I should make my decision consistently with those other decisions. The problem is that cases always turn on their particular facts. So to give you an example, Lilia, it's a very timely question because I have just written an award in relation to a demurrage dispute, and in particular an ICE clause in a charter party. And I was referred to an earlier arbitration that was reported in LMLN, but when I looked at it, it was very clear that the relevant wording was slightly different. And also the factual situation was clearly different because the vessels had joined the ICE convoy. Although it related to the same port, they had joined the ICE convoy at a different position. And so I could not really take any guidance from that earlier case. But so to summarize, I'm being a little long-winded, I'm afraid, because I think it's an interesting and difficult question. But I think to summarize, as arbitrators, we should always look where possible at other decisions of arbitrators when they are referred to us. Of course, it's not our responsibility to research these things. We shouldn't go away and look for them. But if they're referred to us, we should consider them and consider whether we can make our decision consistently. But there is no strict binding precedent.
Thank you, David.
Thank you very much. Thank you very much for that. Just a very quick remark on that, because I'm facing now the same situation as you just told in your example with demurrage. Yeah. So, and I just decided for myself, I just found few awards from previous similar cases, but of course I do not know the factual background for that. And I decided, okay, I need to be consistent, but I also just decided, okay, I'm not bound with the awards of the other tribunals. That's why I do not refer to the awards from the previous tribunals, but I'm consistent with considering the issue, considering the problem that I have at hand. So this is how I deal with this problem, because it is really a very complex problem, how to deal with that.
Yeah.
Thank you,
Thank you,
Livia.
Livia.
Yeah, I'm sorry, time so short. He had to leave the webinar very shortly. David, as I had said to you that ad-hoc arbitration is very rare in Vietnam. Actually, there's only one case reported.
Really?
So, yeah, we are not very familiar with the ad-hoc arbitration. We are familiar more with institutional like SIAC or VIAC or ICC. So, am I correct to understand that NMAA basically works as an appointing authority and offers the NMAA term similar to the untitled arbitration rule for the ad hoc arbitration? Is that correct? And,
yes.
And a Vietnamese company like a shipping company or insurer company who is not a member of NMAA, can they agree to apply NMAA rule for their own dispute? Thank you.
Yeah, thank you, Jean. Taking those questions in reverse order, the answer to the second question is yes, most certainly. Anybody can agree to LMAA terms. It's really important to understand that the LMAA is not an institution. It's an association of practicing arbitrators. And our role is, first of all, to promote London arbitration or promote ad hoc arbitration on LMAA terms. And secondly, to promote best practice among LMAA arbitrators. But the LMAA terms which we publish can be used by anybody. You don't have to come to the LMAA to conduct your arbitration. You can just agree contractually in your contract that the LMAA terms will apply to disputes. Anybody can appoint, can agree to those terms. And the other thing is that it is not necessary to appoint LMAA arbitrators unless your clause says so. Sometimes an arbitration clause will say the arbitrators must be members of the LMAA. But if it doesn't have a qualification of that sort, then you can appoint anyone. Very commonly, I find myself on tribunals with barristers or retired judges who are not members of the association, but who nevertheless have agreed to arbitrate on LMAA terms. And I think I would encourage arbitrators and parties in Vietnam to think about ad hoc arbitration because you have this flexibility. You can have a set of terms which anybody can contractually agree to apply. You might develop your own Vietnam maritime arbitration terms, which would be capable of being chosen by parties without the need to have any institution. That would give you a large degree of flexibility.
Okay, thank David. I see Samatha now on the screen. Would you like to raise a question to David, Steward? Samatha?
Yes, hello, good morning.
Yeah.
Thank you very much. Very nice to hear you. My greetings to all of you from Germany. I am interested in the question of Irina, most of all, but all the other questions are very interesting too, of course. But as she is seeking for a solution for her under $50,000 problem, maybe she could negotiate on an extra clause and just have it dealt out in another way, because of course she's free in having her negotiations at any time. I think there might be some rule of law excluding something like that. But I'm not familiar with her rule of law applicable, of course. But probably there should be a way to have an individual negotiation on such a clause, and also to have a certain individual, as David also referred, that his LMAA arbitration is an individual associative model law that she could apply for, and just install the rules that are matching and yeah, handleable for the parties to come to a conclusion. So
Yeah,
thank you.
Thanks so
Yes,
much
thank
for
you,
your
Samantha.
comment.
That's interesting. Thank you very much.
Yeah, there is now more than 3 p.m. local time. I don't want to keep you longer, so if I miss your trip.
Dzung, I can stay a little bit longer if you would like, but I'm in your hands.
It's great. Anyway, I will upload with your consent. I will upload your slide in the website of ADR Vietnam with your full contact detail. So if any participant want to raise question to David, you can write to him and expect he reply. Right?
Yes, I understand that Dzung is going to send everybody a reading list. And I recommend in particular a book called London Maritime Arbitration, which is written by a number of LMAA members. I find that very useful and it's very practical. And also, please, if you have any questions or you would like to be in touch, please do feel free to email me. I'm always happy to hear from you.
Thank you, David, for your attendance and for your kind support to us. Now, leaving London, we should come back to Vietnam. And the next speaker will be Miss Dang Vu Minh Ha. All right.
Thank you and goodbye, everybody. See you in Vietnam next year, I hope.
Goodbye, David, and have a safe trip.
Thank you very much.
Bye. See you.
Ha is a partner of Dzung SRT Associate Hammer Office. Her expertise is specialized in all area of commercial law, insurance law, and maritime law. Minh Ha is academically well trained on the career of goods by sea. Thus, with Minh Ha's substantial expertise, she can provide valuable advice and practical support to her client, including leading international shipping law firm, P&I Club, S&M underwriter, ship owner, and top multinational shipping line. She has also actively worked with the Ministry of Transport and Vietnam Marine in improving the Vietnamese legislation related to the ship arrest. Additionally, Ha also specialized in international commercial law and has participated in both shipping and ADR group at SRT. Furthermore, she has been with various of domestic and national arbitration at various institutions locally, VIC, and internationally like SEC, SIC, SCMA, while also assisting foreign clients in recognition and enforcement of several foreign arbitration awards in Vietnam. So, stemming from a shipping lawyer, also involved in insurance dispute resolution, starting from marine insurance dispute and extending to other non-client insurance, such as property insurance and construction own risk policy. So, we will here to speak about the maritime and insurance arbitration in Vietnam, and as whether the ad hoc arbitration is an option for us to consider. The floor is yours. You have only 15 minutes to speak. Thank you.
Thank you. Thank you. I will keep it short. Thank you thank you ADR Chamber for inviting me to attend this webinar. And yeah, I find it very interesting in hearing Mr. David on the LMAA arbitration. And from the perspective of Vietnam, I would like to share some thoughts about the ad hoc arbitration in Vietnam, as well as arbitration in maritime and insurance sector. First of all, I would like to share some thoughts about the ad hoc arbitration in Vietnam. Let me play my slide. Okay, so as all of you who are from the insurance companies or Vietnamese shipping companies, you are quite familiar with the institutional arbitration, where the service of documents will be done by the arbitration center. But for the ad hoc arbitration, the service of documents must be done by the parties themselves. For example, the claimant, in order to commence the arbitration, have to send the statement of claim or request for arbitration, or you can call that request for arbitration, to the respondents, and then in following that, on the if the parties cannot agree on any other matters, then the communications between the parties and the arbitration and arbitral tribunal shall be made by the parties themselves without the help from any institution. Furthermore, regarding the appointment of the arbitrator, it is good for the parties to choose the arbitrator themselves. But from our experience, we find that in many cases, the parties cannot appoint an arbitrator for many reasons. And in such a case, an appointing authority is required under the law on commercial arbitration in Vietnam. The default appointing authority shall be the Vietnamese court, but the parties are free to agree on other appointing authority. For example, the parties can agree on the LMAA as an appointing authority. Further, regarding the conduct of arbitral proceeding, unlike the institutional arbitration, where the parties have to follow the arbitration rules of such an institution, and in ad hoc arbitration, there is no specific rules unless the parties agree on. And in such a case, we see that usually the party can refer to the unscriptural model rules as arbitration rules to govern the arbitration. If they cannot agree from such a rules, and then the parties are free to agree on any rule, any procedure matters that they would like to follow, or the arbitral tribunals will have a discretion to decide on the conduct of arbitral proceeding. One final point on the ad hoc arbitration in Vietnam, which is very significant, is the registration of an ad hoc arbitral award. Unlike the institutional award, the ad hoc arbitral award in Vietnam must be registered to the court in order to have it enforced. However, it should be noted that the registration would not be a step to give the effect to the award. It just is a procedural issue, and from the experience, we see that the registration of an ad hoc arbitral award is not really a problem. Regarding the registration of ad hoc arbitral award, we also want to share about, because the Vietnamese court is familiar with the registration of ad hoc arbitral award in Vietnam. So in the enforcement of foreign ad hoc arbitral award, they may also inquire about the registration of such an ad hoc arbitral award. For example, the LMAA arbitral award will be considered as ad hoc arbitral work, but there is no such a requirement in London or in the UK for such a registration, and then it in the enforcement stage, we have to explain that to the court. Next, I would like to share some notes for the marine insurance arbitration from the perspective of Vietnam. First, it's very important. One of the most important thing, not only in ad hoc arbitration, but also in institutional arbitration, is choosing or selecting good arbitrators. As they say that the good arbitrators could create the good arbitration, and it is one of the things that could make the success of the arbitration. And one of the matters that related to the choice of arbitrators is the independence and impartiality of the arbitrators. And for the marine and insurance arbitration, it is quite difficult to appoint arbitrator, because that the pool of arbitrators in that field is not much, and there would be a lot of conflict of interest that the arbitrators may have, and then they have to refuse the appointment because of that conflict of interest. But I think that problem could be cured, because even in the VIAC arbitration, you do not have to appoint only Vietnamese arbitrators. Also foreign arbitrators who are have experience and qualification can also be selected as arbitrators, and therefore the parties can also consider other candidates who must be, for example, lawyers or adjusters or inspectors, and even the staff from insurance companies to decide on the matters depending on the nature of the dispute. Secondly, I would like to point out some criteria for selecting a good arbitrators. Firstly, it is the qualification and expertise of the arbitrators is one of the most important things. We do not need the arbitrators to be kind of meeting any degree, but the real expertise and experience of the arbitrators would be considered, especially regarding to the nature of claims. For example, in the case of for example, in the case of insurance, marine insurance dispute, we may want to select an arbitrator who would be familiar, who would be expert on shipping or shipping matter and insurance matters. Furthermore, one of the other issue that should be considered is the language of the arbitration, and also the language of the arbitrator. It is good to have an arbitrator who can understand the documents and evidence submitting by the parties. So we should choose an arbitrator who are influenced on the language of arbitration. The state of arbitration is also an issue to consider, even if in ad hoc arbitration, because in ad hoc arbitration, the parties would try to saving the cost by cutting down the cost for traveling or accommodation of arbitrators, and therefore the seat of arbitration and the place of the arbitrators is also the issue to take consideration. Furthermore, another important issue is the availability of the arbitrator. We understand that the famous arbitrator or the good one are always very busy, and therefore they may refuse the appointment because they really do not have time. So before selecting an arbitrator and appoint that arbitrator, it is advisable that the party should consult with that arbitrator or ask that arbitrator first about whether he is available for this dispute, whether his schedule would allow more appointments. Other factors can also be taken into consideration is the procedural matters or all the rules of the arbitration, because we all want to appoint an arbitrators who are familiar with the rules, or want to appoint arbitrators who would be an expert on the procedural matters if it is issue in the dispute of the parties. Next point, I want to like to note about the applicable law. In the as for the dispute between the insurer and insurer, the parties only choose the law in their contract, and that law must be followed by the arbitral tribunal. But as you may know, the law of insurance of Vietnam is adapt a lot of concepts, a lot of matters from the English insurance law and also English marine shipping law. And then even in case the parties do not choose English law to be the applicable law for the dispute, we see that in many cases we have to refer to the English law for the interpretation of the contract. And then I should put special consideration to the English law in the applicable law. And in such a case, in our experience, we have to also invite the legal experts from who are qualified to advise on English law to provide an affidavit on the point of law. And it is very common in arbitration. And also another issue which is a very big problem in the maritime dispute is a title to sue. As you may know, there in the for example, in the charter party dispute or in a dispute arising from a bill of lading, we have a chain of parties from the head charterer, from the head owner to the disponent owner and the charterer, and then it would be very much difficult to identify who has the title to sue, and also if and also the party should sue whom the party should sue, and if the title to sue is wrongly identified, and then the parties would waste of time and monies, and then it reveals that the claimant does not have the title to sue, or the correspondent is not the person that should be sued. And Also, another issue relating to the title to sue is subrogation. It is very common issue in the marine in the insurance arbitration. We all understand that after the insurer paid the indemnity to the insurer, they will be subrogated and to claim the third party for the recovery of the claim. But one question is that whether the subrogation also means that the transfer of the title to sue. This problem is cured by the resolution of number 1 of the Supreme People Court, where the court expressly explain that the arbitration can also be transferred to the insurer after can be transferred to the insurer after the subrogation. And we see that a lot of cases in VIC where the claimant is not the insurer, but the claimant is the insurer, and they take the subrogation to claim against the third party. But now on the subrogation issue, it should also be noted that in order to have to avoid any challenge, and then the insurer should also put special attention on the subrogation, on whether the subrogation receipt have enough information to prove the title of the insurer to sue the third party. Next issue also is a very controversial issue with the time bar. Under the if you are familiar with the Vietnamese law, and you can also see that under the law on insurance business, the time bar is 3 years, but from the Maritime Code of Vietnam, the section related to marine insurance, the time bar is only 2 years. And so there will be a question on which time bar would be applicable. And in such a case, the maritime insurance, which either a specialized law for the maritime insurance issue should be prevailed. And another issue is when the time bar commence, both the law on insurance and the maritime code also provide that the time bar will commence on the time of dispute arising. But when the dispute arising is also a controversial matter, and we see that the Vietnamese court heard that the dispute only arises when the parties cannot negotiate anymore. For example, in case the insurers, they said that it can be counted from the moment when the insurers refuse to refuse the claim of the insurer, and then the time bar will commence. And also,
sorry to interrupt. Can you sum up, please? Thank you.
Okay. Unlike the English law, the Vietnamese law does not allow the extension of time bar. And finally, one of the very important matter in the insurance and maritime arbitration is the evidence and witness, because the bundle of documents in this type of dispute would be very huge, and it is advisable that the parties should keep and carefully collect the documents in order to preserve the evidence. And also the party can invite the expert witness to the hearing for for in order to protect the position of the parties in the hearing. In such a case, it is advisable that the expert witness and the affidavit of the expert witness should be submitted before for the consideration of the arbitral tribunal. And that's the end of my presentation. I'm sorry for keeping it too long. Yeah.
Thank you. Now it's time for question. I understand that among our participants, there's some experts in the field too. So I would like to invite an arbitrator in Singapore to share his personal experience in this field. Yeah, Mr. Chayam Singra, can the host open his mic? Yeah. Hello. Can you introduce yourself and please share your personal experience in the field? Due to the time constraint, would appreciate if you try to give a short comment. Thank you.
Thank you, Mr. Nguyen and Ms. Tang Yu and Ms. Lin. Thank you very much for inviting me. And it was very, very interesting to hear David setting the platform for everyone, and Ms. Deng Vu to give us some flair of the Vietnam arbitration matters, especially for maritime and insurance. I would like to share with you the application, what you heard so far, the benefits and the basis, how to start with the ad hoc arbitration and how better it is as compared to institutional arbitration. And then some key points which Ms. Deng Vu Minh just highlighted. Award registration, ad hoc arbitration award registration requirement in Vietnam. And the Vietnam arbitration does not require Vietnamese arbitrators for international arbitration. That's a very good development over the last 10 years in Vietnam. I think that was a very good point. And then time bar. So I'm just going to give you a flair. If I can, will I be able to share the screen? Instead of I talk, I will give you a scenario. And from this scenario, you should be able to see how ad hoc arbitration for maritime disputes and insurance claims is much, much better as compared to institutional or courts. Let's look at this example of an, are you able to see my screen, everyone? Okay, good. So let us see a Lpg tanker, which is very common in Vietnam. So if I take a Lpg cargo, there is a producer and there are types of cargoes. There is a charter party. There's a sales purchase agreement, Lpg seller, Lpg buyer. Then there is a receiver terminal and there are transporters and there are end users. So during this transshipment or the shipment of Lpg cargoes, which is in parcels, just like old times general cargo ships, if that gets contaminated or that there is a delay or there is any possibility of cargo insufficient quality or quantity, how many parties are affected? Which party is going to sue who? And how the owner will be held liable to who? It's a very complex scenario. All these parties will be suing each other or they will be after the owner of the ship. If you look at this scenario and you take the case to start arbitration in an institution, you will have to go through the bureaucracy of the procedure, of the documents, of setting the, bringing out the arbitration clause, selecting the arbitrator. Easily will take away 3 to 4 months minimum. If you go to court, how many court cases and which country's court? If you go to arbitration like LMA or SCMA under those terms, or even if you go to the arbitration clause of the charter party, or the cargo sales purchase agreement, or bill of lading, or contract of affreightment. Under this arbitration clause, if you take an ad hoc arbitrator, he can listen to every party together. Only thing you have to make sure that the ad hoc arbitrator is from maritime field. He's professional in the industry, he knows about it, and he also knows the law. It's not necessarily that he knows about the ships, but he also knows the maritime law, because here multiple laws are applicable in this one slide. And going through the courts, you can spend 10 years, 15 years. This case is a real case I have brought in front of you. This has spent more than 10 years, and none of the party received any judgment to their favor. Everybody has made lots of money they spent and made nothing out of it. No sense. Another case, I give you a similar scenario. Contichem sold butane to Glencore. Glencore sold to Glencore International. Glencore International sold to PetroChina. And it is transported. Along the way, it has changed hands. Now there was a delay claim. So GI, which is Glencore International, paid to PetroChina for delay because PetroChina is an end user between GI and PetroChina. So they settle. Can GI claim for Contichem? Contichem is the original seller, but in between it has changed hands. So we have banking institutions involved, we have sellers, buyers, and middlemen involved, and finally the ship owner, which has caused the delay. So if you have this kind of a case, you want to go to the institution and want to submit your claim about which party is going to start first, because everybody is going after the ship owner, or no. So it's very difficult to establish who is liable, who should start, who is the respondent, and who is the claimant. Claimant is one, yes, he wants to start, but who is the respondent? How many respondents? It's a perfect case for an ad hoc arbitration. Let's take one more, very quick one. This is also a real case, which you can see the name on top and you can get the case details. This is the tow bulk carrier, which has been purchased by Chenko from Atlas. Chenko and East Faith are partners in buying. So Chenko spent the money in buying the vessel. East Faith spent the money in engaging this truck to tow this vessel to China. Atlas is a seller. Atlas did not disclose that the bottom of the ship was cemented. It does not have a steel plate on the bottom of the ship. Along the way, the tug lost one engine, so it's running on one engine. Instead of reaching in 30 days, it reached in 40 days and during the holidays. And when the dispute started in court under the English law, who is the real owner of this tug? There is a charterer, there is a tug owner somewhere, and there is a sub-charterer, sub-towcon, and there is a management and operation company, and there is a head owner of the bareboat charter. So many parties have to answer one claim against the tug. What happens? The dispute is only small. There was a delay in delivery, so they want to claim a compensation for the delay, that's it. But the case has to go through the court. Even the judge also say, I feel very pitiful that for such a small claim, so many parties have to submit their submissions. And finally, it is settled, which is not even 10% of the legal fee. The award was not even 10% of the legal fee. If it is going to the ad hoc arbitration, it will be settled within a day or two or a week, like David has given a very good example of his experiences. It will be settled within a week. All these things are very clearly understood to me as a mariner, to any other mariner or any other maritime lawyer. They know the scenario. Once they get the picture, they get the scenario. Okay, so, make your submissions and here is the decision. And all in context of the law with the proper procedure. So when we settle a P&I claim or insurance claim or a claim due to any contractual dispute, we have to take into account the impact of the decision. Whether there is one claimant or one respondent, but impact of the decision will have on many parties. It will have impact on the crew, It will have an impact on the cargo interest. It will have an impact on the charterer, insurers, owners, environmental issues, classification society, and authorities. So insurance claim is not a simple and straightforward claim. It takes a long time. Insurance claim, the small claims like less than $1 million, maybe they will settle, but anything more than that, it takes years and years. Why? When you read the insurance cover, you have to see what it is covers. It very simple, small letter, it will be written caused by, and then there will be a list of issues. If the incident or the root cause is not caused by one of the covered under the insurance policy, you can't claim. You waste so much time in starting the proceedings, but finally find that it was not caused by this, but it was caused by willful misconduct or caused by one of the exclusions clauses. If you look at the insurance cover, you will find there are 2 or 3 pages on exclusion clauses. Following causes are excluded. And inclusion clauses, maybe 1 paragraph and all covered in 1 paragraph. So we have to read this with a microscope. And especially when going to arbitration, litigation, of course, is you can hear hundreds of cases on insurance. And I'm going to share with you what happens in litigation. This is a summary published by IUMI. How many claims are settled within the first year? Can you see? You can't see this bottom line, only this much. And what is the claim? Less than 1%. Only this amount is settled in the first year. Why? Because this is very low amount. So insurance company, for good relationship, they may just ignore it. But if the claim gets higher, paid in the second year, how much? Less than 10%. This is a trend from 2011 to 2021. And if your claim is further higher, 7th year, 8th year, 9th year, 10th year, outstanding. Outstanding is still quite a lot. 10 years and still outstanding. That shows this is the litigation cases. This is not the summary of the whole world. This is only Europe. If I take the whole world, you can imagine how much time you'll be spending on insurance claim. I think Ms. Minh has just given you an example of the insurance claims, how to get the arbitrator, how to get the people expert in this. Those are small issues actually, but going to the court is not the answer. This is not published by arbitrators, not published by lawyers. This is published by insurance underwriters themselves because they are duty bound to show to the world how much premiums they collect and how much they pay. This is 10% of the premium, 20% of the premium. Moment it goes 20% and above, you will be hanging in the court for many years. So with that, I would suggest that to avoid the time bar, which is less than a year, especially in cargo insurance, maybe it is within 2 months or within 6 months. And if maritime claim in 1 year, and if any passenger claim is 2 years maximum. Time bar is very important. So you must start your proceedings, and to start a proceeding for arbitration is just 1 email. 1 email to the other party, your case is registered, it has started. After that, you can discuss and you can negotiate. So that was just a few points I wanted to highlight the benefits. And I had the question of Ms. Irina in the beginning, the $50,000, and there was actually that is so-called a clause, which is called pathological clause. Sometimes there are pathological clauses in the charter party or in the contracts, hurriedly negotiated without thinking about the dispute. That case is a real case, the 50,000 for a small claim, and after that, what happens? That has gone to the court, English court. It has gone to 2 courts. It has gone to arbitration. Arbitrators started under the LCIA. Another arbitration started under LMA. So if you're interested, Irina, about that case, it's a very interesting story to read about some defunct or pathological arbitration clauses. With that,
you,
I
sir.
think I would invite some questions, if any, from you.
Thank you, sir. I'm afraid that we are running out of time. So I only have a question. I understand that you're based in Singapore. When talking about Singapore, we normally remember the name of SIAC and SCMA.
SCMA, yes.
Yeah. So for the ad hoc arbitration in Singapore, normally if you need a appointing authority, which institution you will prefer to choose as a appointing authority in your ad hoc case? And the second question is, which arbitration rule normally the ad hoc arbitration tribunal will apply for the maritime or insurance dispute?
Thank you. SCMA is a Singapore Chamber of Maritime Arbitration. So SCMA is similar to LMA. The rules are quite similar. Everything is almost similar to LMA with some minor changes. SCMA does not get involved. If you want to appoint for ad hoc arbitration, the parties can go to the list of arbitrators on the SCMA panel and don't have to go to SIAC or don't have to go to court. Just go to the SCMA. If parties cannot agree, they can write to the registrar of SCMA. Registrar of SCMA can appoint for the parties. And that's a nominal fee. I think it's less than the LMA fee or almost the same fee as LMA. And SCMA cases are, I have dealt with cases, they had SIAC rules, want ad hoc arbitration. They're stuck with the SIAC procedure. And somehow they picked my name from the SCMA website and contacted me. Within a week, that means me and the two parties lawyers agreed to switch the rules from SIAC to SCMA rules. Even though the charter party says SIAC and Singapore as a seat, we managed to agree on SCMA rules and everything was resolved. It was about consignment for a cargo shipment. We managed to settle within a month. And that is an ad hoc arbitration. Both parties agree to common sole arbitrator, it is much faster. If parties cannot agree, it's fine. You can have 3 arbitrators. You can choose yourself from the list of arbitrators on SCMA website, which is almost the same as on LMA website, same arbitrators. Because in maritime, international arbitrators are common everywhere.
Thank you. Thank you. Thank you very much for your attendance, for your experience to share with us. Although we are late, but I would like to invite another participant from Europe who may share with us about her own experience in the field. So Lilia Klochenko, is that correct? Yeah. Yes, host, can you invite her to speak? Can you promote her to the speaker, to the panelist? Yeah, Lilia, yeah.
So,
hello.
Can you hear me again?
Yep.
Yeah. So I just, first of all, I would like to thank you also, Mr. Tintra. I think that the presentation of figures and also your experience how to deal with really complex disputes and complex cases in insurance that are combined sometimes with a very specific industries like maritime or construction or such is very important. And I would say that probably it would be also very interesting to make or to prepare to organize a webinar just where we could discuss various experience from many jurisdictions, just combining the common law and civil law experience and practice, because I would say that for your point that the cases could be proceeded for a long period of time. I would say that I have various experience. Yeah. In any case, I'm a fan of the arbitration for difficult, complex cases, exactly for or within the ad hoc proceedings, probably because my experience is not bad. I would say even very good in terms of efficiency. Where I was a counsel to the party, or where I was an arbitrator, served as an arbitrator. But in any case, I would say that for the complex cases, the ad hoc arbitration is a very good solution if the parties take care and take their attention on how to choose an arbitrator, a right arbitrator. And with this, I would like to share also my very beginning, my starting example that I had. David told us about his experience, the very first experience for the maritime arbitration, ad hoc arbitration. I had also one, and it was exactly a case for, I don't know, 20 years ago. I was a counsel to the party, and the party, for a very complex case, just has chosen an arbitrator with no law knowledge or experience, and with no industry experience or knowledge. And we asked why for, what is the reason for that? And the party just explained he is a wise man with a long life experience, and this is the key issue. Okay. I think that the outcome of the proceedings itself was great. But why? Because the other party, the respondent party, just paid attention to this fact and nominated, just chosen a very, probably not prominent, but a person who had a very extensive knowledge and experience in industry and to somehow in law. And the institution just nominated an umpire who was very familiar with the arbitration proceeding knowledge and experience. And it was a great composition for the case. Interestingly, that the first arbitrator, we are not involved, of course, in the deliberation of the arbitrators, because you know this is confidential. But in any case, interestingly, that during the proceedings itself, the first arbitrator was always silent. Of course, probably it was a great experience for him, but my key point is that the profile of arbitrator and the personality of arbitrator is a very important issue when we are talking about the ad hoc, pure ad hoc, or by institution administered ad hoc proceedings. It is a key issue. How to proceed with that? What is, or where is a balance? In my view, it is a case to case experience or issue. Yeah, because it depends on many factors. But I always say that to myself and to my clients, to my colleagues, that we have to deal with that when we draft the arbitration clause. I'm sure that you saw many clauses where so extensive, specific requirements as to arbitrator personality are set forth. I don't know, 15 years experience in a very certain industry like reinsurance on the very specific level, like, for example, management board or supervisory board level, and so on. And with that, sometimes also that the nationality of the arbitrator should be the same as the nationality of the party. And what could you have at the end when the dispute arises? You could have a deadlock situation where you are not able to make a right choice for the arbitrator. You do not have such an arbitrator, and you need to deal with a lot of disclosures and new negotiations between the parties. So this is my experience with that, and I think that this is also an illustration how complex could be not only the case itself with this combination of law, industry, specificity, but also in terms of proceeding itself. in any case, many thanks for organizing this great webinar, and with so great panel of speakers, and for possibility to discuss.
Thank you, Lilia Kolochenko. I'm afraid that we have to stop here because it's running late, about half an hour. Thank you for all audience to join us this time, and thank you for all the comment, for all the idea you have raised. So we have to close the webinar here, and we will upload all the slide to the website of the ADI Vietnam Chamber. And Mr. Jayan Brinker, would be great if you could send us your slide and your full detail. So some of the audience may want to contact you for inquiry, or maybe for a potential appointment you as an arbitrator, right?
Thank you so much for inviting us.
Then the audience can contact directly with the speaker to ask any question related to the ad hoc arbitration in the maritime and insurance sector in London, in Singapore, or in Vietnam. And I would like to welcome all of you to the next webinar this time next week, Friday. The topic of the next webinar is international trade arbitration. It will be presented by the Selin Tung, partner of Wise White International Law Firm, together with Dr. Nguyen Thị Thu Trang, the Arbitration Manager of Dzung Associates. So the next webinar will be very specific on the arbitration in international trade field, focus on CSD and other related law. So I hope that we will see you in the next webinar. And again, thank you very much for your time, and have a good weekend. Thank you, and goodbye. Thank you.
Thank you very much. Thanks a lot.
Thank you. Thank you.